Diolch, Lewis. And before I begin, Lewis, I believe that I should declare an interest in that I have been a sitting magistrate, a JP, for 15 years, and I am still technically a JP. My desire to make a contribution to this debate is that I wish to defend certain aspects of the British judicial system and those who administer it, and to reassure the general public who may hear this debate that in all the time I sat as a magistrate, including a number of years as chair of the bench, I never witnessed anyone being sent to prison unless all alternative interventions had been fully and unequivocally explored. Indeed, throughout my years as a magistrate, it was emphasised to all those involved in the judicial... Yes, sorry, Jenny, of course.
I just wonder then if you can explain why it is we still send women to prison for not paying a television licence. I'm not suggesting they shouldn't pay their television licence, but there have to be alternative ways of making them comply.
Well, indeed, throughout my years as a magistrate, it was emphasised to all those involved in the judicial system, magistrates, judges and, of course, the probation service, that incarceration was to be the final and ultimate form of punishment. Yes, on rare occasions, mistakes may be made, but that is true of any institution, especially one such as the judiciary, dealing with almost insurmountable problems linked inextricably to a rising tide of serious crime. Of course. Yeah.
We heard earlier on how, under Michael Howard, when he was Home Secretary, the prison population was 45,000, and within 5 or 6 years it had gone up to 80,000. How can that have happened if what you were saying is correct?
Excuse me, I'm just explaining that. I'm saying that dealing with almost insurmountable problems linked inextricably to a rising tide of serious crime. This rising crime rate includes violence against the person, sexual offences and widespread trafficking of drugs, as acknowledged by this Ministry of Justice report of 2013. We can add to this new forms of crime increasingly associated with the internet, such as child exploitation and fraud. And yet, item 1A in this debate seems to suggest that it is the criminal justice policies which has caused this rise in the prison population and has nothing to do with the rise in crime itself. Of course.
The member to intervention, and I bow to his experience as a magistrate. But the question is the sentencing guidelines and the alternative mechanisms that could be looking at in which we can work with individuals who are found guilty of an offence. Do you agree, therefore, that we need to refresh those sentencing guidelines because there are people who are being incarcerated that should not be incarcerated? There are different ways in which we can still punish a person but not put him in jail.
Well, I'm sorry, David. I am very affair with the sentencing guidelines, and I can assure you they are there not to send people to prison. I will say here that I have a great deal of sympathy with the views expressed in items 1B and 2B. I believe that there should be a substantial expansion in secure mental facilities as alternative to normal prisons, and that some, but by no means all, of our prisons lack the facilities needed to rehabilitate prisoners. I will just note here, David, and I declare no bias one way or another, that there are many in this chamber who oppose the prison at Margam, which would be able to offer many of the facilities to Welsh prisoners. I wish now to turn to item 1D and item 2A listed in this debate. The first item again suggests that women, in this instance, are sent to prison for minor offences. This is patently not the case unless there are multiple minor offences involved, and again I reiterate that all other interventions would have been comprehensively explored. Only when the person convicted of a crime refuses to engage or accept the alternatives is the option of prison even considered. Item 2A suggests that alternative methods of punishment are either not available or are not being used. Again, this is an utter fallacy. Fines, probation, community orders, including work in the community, curfews and electric tagging, are all considered and used extensively before anyone is committed to prison. One extremely worrying consequence of these two clauses is the inference that if the perpetrator of a crime is a mother, she should be treated differently to any other person who commits similar crimes, whether they be petty or otherwise. What signal does that send to all the hundreds of thousands of mothers in our society who do not commit crime, even though their circumstances may well make them vulnerable to turning to this alternative? I will add, non-payment of fines is not a minor or petty offence. It means that it is left to the good, honest, hard-working and often poorer members of society. No, David, I have to finish now, I'm sorry. Society to pick up the bill. Finally, although I believe the proposals contained in this space are well-intentioned, and those proposing its contents are well-meaning in presenting it, I contend that it is ill-conceived, naive, and does not accurately reflect the British judicial system. I will go on to say that I will agree with all the comments made in this chamber by all those who have contributed to this debate, to say that post-sentencing we have a diabolical situation within all our prisons, and interventions post-sentencing ought to be our first and total priority. Thank you.